Ladies and gentlemen, as you can all notice, we have a very prolific start to the program here in the presence of our legal luminaries. But it's also time to set the tone for the program on what's in store and what is the theme of the entire program. Ladies and gentlemen, on that note, let's move forward and now invite Shri Shardul Shroff, who's the Executive Chairman, Shardul Amachan Mangaldas & Co., to also share his insights and his views with this gathering. So let's have a huge round of applause and please help me welcome Mr. Shardul Shroff.
Mr. Justice Sikri, Mr. Vishwanathan, and my friend Ravi Kadam, and all of you who are present today. It is indeed an honor to come to this forum and speak about how the law has developed, in a sense that one reviews what has been the annual changes or major litigation or major judgments which is driving the change in the law. Having attended several of the international conferences where the code is debated and the opportunity for investment in distressed assets is discussed, I think the feedback that has come through is that we have achieved in a period of 3 to 4 years what other countries, including countries like USA, developed over decades, and the speed with which the reforms have happened, the speed with which judgments have come through, and the process has been quite remarkable. And we are now just into the phase where there will be judicial reforms or judicial treatment of how cases should be handled, or the legislative response in relation to what is still failing in the system. I think if one looks at this last amendment of 2019, clearly it is occasioned by the NCLAT judgment in the SR matter, which the tribunal evolved a completely new formation which is quite contrary to the traditional banking laws and the process of how banks have been creating priorities or being treated as secured creditors. And their charges are being registered under Chapter 7 of the Companies Act. And the honorable members of the tribunal of the NCLAT got on to a particular gap in the CIRP proceedings, that's the corporate restructuring proceedings, and held on to the principle that there is no constraint among them when they're dealing with a scheme of rehabilitation or a resolution plan, that they cannot change the order or they cannot alter the contracts of the secured creditors and treat both the secured creditors and financial creditors equally. Now, this has a far-reaching consequence in the sense that traditional banking, pricing of loans, the whole security regime, the whole unsecured creditor regime, the operational creditors regime would be shaken up quite substantially if this law was not reversed. And therefore, for the first time in 70 years, in 13 days from the date of the judgment, a change was introduced through an ordinance and then converted, of course, into a proper bill and an act. This is the fastest that any legislature or any central legislature has ever acted, and I don't recollect any such instance other than this particular amendment. And it was occasioned because all bankers across the world, and our largest banker, the State Bank of India, were quite outspoken and did mention that you cannot and should not interfere with the Committee of Creditors' decisions, especially because that freedom is made available legislatively. As Mr. Vishwanathan mentioned, it is almost a sovereign power which has been entrusted to the Committee of Creditors to decide how the distribution will take place. So it's a very unusual case where the resolution plan and the resolution applicant were accepted, and yet the tribunal chose to decide that despite the scheme having been approved and despite the resolution applicant having succeeded, it has the power to modify the distribution among the creditors, that is the financial creditors, unsecured financial creditors, and the operational creditors. This was unprecedented before that. And to equate financial creditors with operational creditors was for the first time evolved in this judgment. So the crux of this amendment, there are 7 or 8 amendments, but the main theme around the 2019 amendment has been the modification of section 30, subsection 2, clause B, because this is where the legislature has brought in the principle that the transfer of property principles of how distribution takes place among secured creditors vis-a-vis unsecured creditors, as also the provisions of section 53 of the code would apply even during the period of resolution and not merely in bankruptcy. Because the principles in bankruptcy were always clear that it would go by a priority, namely the resolution cost first, the workman's portion along with the secured creditors next, and then in a declining order, the equity players being the last. So this disturbance effectively by a judge-made law was the raison d'etre for the modification of the code in 2019. There are some other changes which were also made and which will have an impact of the practice of insolvency, for the reason that one of the most sort of not emphasized amendment is the introduction in the concept of a resolution plan, the ability to conduct a merger or an amalgamation or a demerger. And this is significant for the reason that the previous judicial view was always that it is only the corporate debtor which can be dealt with in the code rather, and to introduce either a healthy company or transferor being brought in and 2 companies being dealt with under the code was not actually permitted. The previous judicial view was to bring in a new company which is not under stress and to use that as part of the remedial action in the code was something which was not contemplated, and actually it was being kept off. But realizing that the complexities of trade are such that it is necessary to have not just the purchase route or not just the asset sale route, which is the traditional remedy that the court applied for more than 2 years. This new area has been introduced, and it will introduce vast changes in terms of how evaluations of corporate debtors and the purchaser effectively, or the amalgamated company, would have to be evaluated. So this is a major practice change, and it will have a tremendous impact, because in a single scheme you could contemplate both the reduction of debt and the introduction of a new party. Currently the processes which have been adopted is cancellation of the equity of the old promoter and introduction of fresh equity in lieu and stead of the lost capital. So I think that's it's not been evaluated by the community yet, and it will come, because I think even the regulator has not been able to assess how to evaluate such procedures, because they're all based on marking systems which do not really extend to a merger, amalgamation or demerger. The other issue which is of a significant change was the complaints that which were being received by the IBBI in relation to the time taken for admission. There is statistics and empirical evidence to show that cases were dragging on for 6 months just to be admitted. Filings used to happen, but they would never come up for decision, and it would really almost take the whole time as is available for the resolution. 180 days or more have been seen in the system, and therefore the government felt it was necessary to put in a provision which says that you will justify why it has taken more than X days to admit the process. And this was an amendment introduced in section 7.4. The other amendment which was introduced, and I think it's more or less, I'm not sure how the judiciary will react to it, because they have developed a regime of their own, in the sense that the time taken for legal proceedings in resolution or in resolving the distress was, even prior to this amendment, 270 days. But those 270 days used to stretch to 400, 500 days, and there are cases which are now almost 1,000 days old, including the one which is being heard by the Supreme Court in SR State. So they actually reversed the judicial principle which was evolved and said that we are giving 270 days, which was the original statute, and 60 more days. That's it. And if you don't finish in that time frame, the company will go in liquidation. It's almost like a statutory period that if you don't come about with a remedy at the end of 330 days, let it go into insolvency. I don't know how this will pan out with the judiciary, because judiciary being judiciary, they will justify a longer time frame, because this is not a clinical, day-to-day accounting for the judges. They have a huge workload, and to experiment with a fixed time dissolution concept is pretty rare. So I don't know how the final thing will pan out. The other changes are in the context of debenture holders and home buyers, which are very large constituents in the creditors category. And there is even now an extremely difficult approach as to how you resolve issues which involve 30,000 or 40,000 or 50,000 people in relation to a distressed home or distressed construction project. And they have brought in the concept of an authorized representative. But how the authorized representative votes, is he to vote on the individual decisions of the class? Is he to vote on the collective vote by majority in the class and represent that as a single vote, was an issue which was contemplated when they amended section 25A under the 2019 code, but it's still not worked itself out fully, and this is something which is again a work in progress. The last two issues effectively concern the binding nature of the order of the tribunal or the NCLAT, wherever the case is finally being decided. And they have categorically stated that the central government, the state government, and local authorities are bound by the decision of the tribunal. So to raise a dispute after the resolution, or to rake up an unpaid government claim, whether it's of the authority or whether it's of the central government or the state government, is something which was clearly frowned upon. And this assumes a great importance now because of the PMLA Act and what is happening in the Bhushan Steel matter, where the authorities, the ED has staked a claim and put a attachment order on the assets which have already been sold and bought by the JSW group. There are now about 7 judgments on this issue as to whether PMLA has a priority over the IBC. And even the appellate tribunal of the PMLA authority has decided that no, the IBC has priority, except for one judgment out of the 7. 6 of these judgments have now held that the Enforcement Directorate cannot attach assets which have been sold or undertakings which have been sold in the context of a resolution plan. So this was one of the reasons which was emphasized and made into law. Then of course the miscellaneous provision in the context of the rule-making power was the scope of this particular amendment. But this is not really the end of the process of continuing change in the IBC. There has been a standing committee which was created by the Government of India, and I am privileged to be one of the members of that committee, where lots of other issues have been debated for almost 2 to 3 months now. and major changes have been effectively cleared through the committee. The cross-border insolvency group was one of the first changes which was gone through as part of the extended form of Section 234 of the IBC. It resorts to the model code of cross-border insolvency, but it leaves open Section 234 by which a bilateral treaty can still play out on insolvency issues, supposing one is not a member of the countries which have signed up to the treaty, then an alternate mechanism could continue in the law. And we've recently seen this in the Jet Airways case, where the Dutch authorities and the Indian authorities collaborated on how to resolve the cross-border insolvency issues of Jet Airways, because it's having locations outside of India also. And I'm sure in the session which comes up for cross-border insolvency, there will be much to discuss, because the power over the assets, if the registered office is here, what should be the principle? If the major assets are outside India, what should be the principle? It's a complete regime in itself as to how it should be done. Plus what happens in terms of authorities which are outside, who would really argue those cases? Can an international RP work in the context of an Indian resolution, and if so, what are the extents of the powers that will be recognized in the conduct of a cross-border insolvency? So it's a major thesis in itself. The second more important one, which has been taken up and actually signed off, is the group insolvency concept, and which is an enormously difficult task, though there are now 2 cases even without the change in the law in India. I happen to have written an article saying that this is, in a sense, again, the judge is creating the law, and there needs to be an appropriate codification of this, because otherwise this will lead to tremendously contrary judgments or processes, which is not healthy. In the cross-border insolvency, the triggers were the ILFS case, the triggers were the Videocon case, and the Amtech Auto cases. So there are lots of cases where there are multitude of companies under a single parent. And that has problems in the law, in the sense that in defining a body corporate, a non-bank finance company is excluded. And in most of the groups, there is always a apex corporation, which is known as the CICs under the non-bank financing regulations, where a single enterprise holds shares of the underlying subsidiaries, and the subsidiaries are primarily working and engaging themselves in the business. The topco effectively is just a mere shareholder of the shares which are downstream in the operating companies. Now, in the ILFS issue, what was noticed was that such companies cannot be brought into the IBC. And therefore, a different process was evolved under the Companies Act, by which the change of board was effected. There is no resolution professional in the ILFS cases, and there are more than 330 subsidiaries in that case. So it's an enormous task, which is already a year, an anniversary in that process has gone by. It is reported that about 50,000 crores out of 90,000 crores is likely to be recovered. So there could be a loss of almost 40,000 crores, which is significant. It's 3 times the value of what was lost in the Nirav Modi case. So you can imagine the kind of money which has been lost in that process. This is true of most of the group companies because of the exemptions which are there in the Companies Act in the space of infrastructure, that the limits of the capital which can be employed downstream doesn't exist in the context of infrastructure companies. That is one of the reasons why you see such a large problem in the ILFS cases. It may not be such a large hole in other cases like Amtech Auto or Videocon, except of course in an oil and gas kind of company, the same levels of investment are large, and losses could be equally large. So that's how the future is being seen in terms of the macro picture. There are of course a lot of changes other than these 2 changes which are also being deliberated. issues in relation to how you could, by notification under the code, bring in financial service providers as part of the regime of the IBC, because you need quick resolution. They will of course not deal with the systemically important companies which are in the non-bank finance space. And simultaneously, in fact, even today's papers mentions that the previous act, which was to regulate banks and systemically important NBFCs, is being revived and may simultaneously be brought in the November-December session of Parliament, which will look after a different method for reviving banks and reviving large NBFCs which have suffered tremendously in the last 5 to 6 months. One more change, which is an interesting change recently discussed, pertains to whether the resolution professional should include the previous official liquidator when the company is facing bankruptcy. And the rationale which has been provided is that there are large conflicts of interest in dealing with large insolvencies, and the government may need at times a more controlled resolution professional, being an officer of the Ministry of Corporate Affairs. I don't know how that will play out, because efficiency is a very critical factor, and knowledge is also a typically critical factor for a fast-track resolution. The issue of sale of a liquidated company or ordered to be liquidated as a going concern is another vexed question, because the very premise of liquidation or an order for liquidation is that all contracts come to an end. Directors get suspended or contracts of directorship come to an end. The workmen's contracts come to an end. The permissions, licenses, approvals come to an end. And then to say that in a liquidation, you can sell as a going concern, which essentially means that the company has not died. It is just in suspended animation, which is not what the insolvency law anywhere in the world says. But it's an experiment which is being tried by our government, saying that, look, in the Indian circumstances it's difficult. You don't have so many job opportunities. The object of the act was to revive enterprises, not to really render them insolvent. So this is an interesting experiment which is being conducted for part of the future. One other suggestion would relate to upsizing the threshold level from the sum of rupees 1 lakh, which is the admission threshold today, to a much higher threshold, so that the volume of matters which lands up in the tribunal is brought down, and the more serious matters pertaining to insolvency are tackled, and time is not oppressive against the tribunal, because if they're to deal with miscellaneous matters and small claims, it doesn't really serve a purpose. So these are some of the changes which are on the anvil. I don't think the last word on what types of changes are still going to be thought through, but there is continuous dialogue among the members of the Insolvency Law Committee, where Mr. Viswanathan is also a member, and almost every 15 days we are having meetings to look at the various questions that have been brought up. There are other ticklish questions which are also on the anvil, but I wouldn't speak about them because there is a case going on which deals with that very subject which the committee thought about. So thank you so much.